Professor Dörfner, in your written testimony, you say the longstanding precedent held there was an implied private right of action in statutes passed to protect a class of citizens, even if there's not a specific authorization for a private lawsuit. The court said that rule is applicable here. The guarantee of Section 5 might well prove an empty promise unless the private citizen were allowed to seek judicial enforcement of the prohibition, close quote, from an earlier decision. But this is ancient history. Today's Supreme Court has outlawed the implied private right of action. Unless Congress specifically says in the statute that victims can sue, they can't. Their only recourse is to hope that a government official or agency will decide to focus on the individual case. And this is symptomatic of what Ms. Lithwick said a moment ago by changing the standing and rightness doctrines, by shifting the burden of proof, by doing away with facial challenges, by making it harder for people to get into court. We've made it very difficult for plaintiffs to assert and protect their constitutional rights. Could Congress change this by passing a general statute that says in the absence of specific language to the contrary, there's always an implied private right of action to protect statutory constitutional rights? Could we fix that?
I think that could be very constructive. The court, again, would get to interpret that, and the question is whether a court interpreting a statute passed next year would apply fully what the Congress this year said about a broad right of action. But I think that would be a very constructive and a good idea.
We couldn't say that with respect to all existing statutes, there is an implied right of action going forward?
That might be a little broad if you said all existing statutes, but I think if you did it by categories, and I'll give you one comparison. For a long time, there were questions about the statute of limitations, because a lot of statutes don't specifically have that. And the court fumbled around for a number of years trying to figure out how to do that, and then Congress, about 1990, I think, passed a catch-all and said for all federal statutes from here on that don't have a specific statute of limitations, it's 4 years. And I think that might be a good model for the kind of private right of action.
Thank you. Professor Francois, you noted the distinction, the empirical distinction that you've cataloged, I suppose would be the word, between statutory interpretation where the court in large decisions, 9-0, 7-2, has generally been less dismissive of the clear intent of Congress, as opposed to in civil rights cases, as opposed to constitutional cases where I think you said in a series of basically 5-4 rulings, the court has gone much farther afield. One might characterize it, I'd be interested in your observation, one might characterize it as saying that maybe there are some people on the court who think that where Congress can correct them, they'd better be a little careful, but where Congress can't correct them except by constitutional amendment, which is very difficult, they can be more contemptuous or more disrespectful of the clear intent and of precedent and substitute their own predilections. Would that be a fair characterization?
I suppose that one might characterize it this way. I think, though, that one encouraging sign in the court's jurisprudence is that, as Professor Dörfner just pointed out, when Congress passes a statute, to the extent that Congress makes its intent very, very clear, then there is a fair chance that the court will uphold the statute. What Congress can no longer count on is for the court to look at its intent and imply any sort of right of action or the remedies. So I do believe, though, that in the absence of statutory text, the court's constitutional jurisprudence, when it comes to civil rights, and one can choose any one of the areas that I just mentioned, it does indicate a certain hostility towards civil rights in general.
Okay. Thank you. Let me ask one question. I'm not sure who to direct this to. In the Northwest Austin Municipal Utility District case, beyond the narrow ruling permitting that district to bail out from the coverage of Section 5, the court included language in the opinion that appears to raise serious concerns about the continued constitutional viability of Section 5. Do you think the Supreme Court was sending a message to Congress, you better do something about Section 5 before we declare it unconstitutional? Were they sending us a message? And what are your concerns about future voting rights cases in light of this decision? And let me make it a little more complicated. starting with the Bernie case, City of Bernie versus, well, maybe not starting, but certainly in that case, and certainly in these cases, and a series of other cases, the court has indicated that that Congress has to have a record to justify its policy judgments. Why is that a concern of the court? Why should the court be concerned with whether Congress is intelligent or well-based or not well-based in its policy judgments? The electorate should be concerned, but why is that a constitutional concern of the court? And why should it affect the constitutionality of what we do, whether we've considered all the factors or not? Maybe that should affect our elections and our intelligence, but why is the constitutionality of what we do affected by whether we've done it based on a lot of facts and a lot of study or not? So it's really two questions. One, is the Supreme Court sending us a message on Section 5 that we had better heed and do something about if we could figure out what to do? And two, the second question I just asked, who wants to do that?
Perhaps I'll start. I think it's fair to say that every decision of the Supreme Court sends some signal. When they're interpreting a statute of Congress, the signals can be more direct or indirect. I think it was somewhat unexpected that so much of the opinion focused on a question that the court was not deciding. That was not expected as we read the decision. But it's also fair to say...
Which question, namely the...
on the constitutional question. So the court essentially did not reach the constitutional question, but spends the first 11 pages of its 17-page majority talking about the constitutional question. We call that dicta in ordinary circumstances.
And the question is that sending us a message?
Exactly. Yeah. You know, why was there so much focus on the dicta on a question that they were not reaching? I think it's fair to say that the Constitution in this area, under the 14th and 15th Amendment, calls for a conversation between Congress and the Supreme Court. Both bodies have a role, but it's important to note that Congress has express powers in this area, express powers that have been recognized in a whole host of decisions in the voting area and in other contexts. And even in the Bernie decision on this question of Congress doing its homework and what the record looks like, there is a not often quoted line in Bernie that says that the analysis in ordinary circumstances does not properly begin with what the record looks like, but it begins with who is the body that is constitutionally appointed to decide. People don't talk about that line in Justice Kennedy's opinion, but I think that that is the important piece. Congress has a role in making sure that all citizens can vote unfettered. That's the duty that Congress has, and it would be remarkable for the Supreme Court, particularly after the history of the Supreme Court having struck down voting laws and having seen the country walk backward after those laws were struck down. And I think Chairman Sensenbrenner and Conyers filed a brief on this topic in the Supreme Court case. It would be extraordinary for the court not to take heed of that important history and step over the line into second-guessing the policy judgment. But obviously, the Supreme Court continues to have some difficulty with the way in which Congress is discharging its responsibility. That, to me, does not suggest that Congress should cut and run, but of course it's up to this body how it proceeds.
I thank you. My time has expired, although I'd like to pursue this. My time